बिस्मिल्लाहिर्रहमानिर्रहीम। मोअज़्ज़ज़ ख़वातीन व हज़रात, नॉलेज शेयरिंग के साथ मोहम्मद नईम नौशाही एडवोकेट हाज़िर खिदमत। लास्ट टाइम हमने रजिस्ट्रेशन ऑफ FIR के हवाले से गुफ्तगू की थी। रजिस्ट्रेशन ऑफ FIR को सेक्शन 154 ऑफ द कोड ऑफ क्रिमिनल प्रोसीजर 1898 डील करता है, और इफ़ any cognizable offence is committed, then under section 154 of the code, case is registered against the accused. Today the topic is investigation. मुकदमा दर्ज करने के बाद जो मरहला आता है वो इन्वेस्टिगेशन का है, एंड वर्ड इन्वेस्टिगेशन is defined under section 4 of the code clause L. Investigation includes all the proceedings under this code for the collection of evidence conducted by a police officer or by any other person other than a magistrate who is authorized by a magistrate in this behalf. In this regard, so far as the higher courts are concerned, higher courts have laid down a law regarding the investigation, and according to that, investigation generally consists of the steps: number 1, proceeding to the spot; number 2, ascertainment of the facts, circumstances of their case; number 3, discovery and arrest of the suspected offender; and then collection of evidence relating to the commission of the offence. Then number 5 is formation of opinion as to the trial of the case. Now, for conducting the investigation, the powers of the investigating officer are mentioned in section 160 up onward to section 175. So, section 160 is important section. This section 160 gives power to the investigating officer to summon the witnesses for recording their statements regarding the case which is under investigation. This section I would like to read out, is very important. It says, any police officer making an investigation under this chapter may, by order in writing, require the attendance before himself or any person being within the limits of his own or any adjoining station, who from the information given or otherwise appears to be acquainted with the circumstances of the case, and such person shall attend as so required. So, according to this section, the investigating officer summons the witnesses to record their statements, and statements are recorded under section 161 of the Code of Criminal Procedure 1898. Ladies and gentlemen, this section is very important, and it gives the powers to the investigating officer to record the statements of the witnesses, which are recorded separately, and in the case diaries which are recorded under section 172 of the code, it is mentioned that the statements of flaw witnesses have been recorded. Now then, the section is 162. The statements recorded under section 162, 161 are used as required under section 162 and none for else. This section 162 says, no statement made by any person to a police officer in the course of investigation under this section shall, if reduced into writing, be signed by the person making it. First of all, this section says that the statements recorded under section 161 of the code are not required to be signed by the person who makes the statement. Then the statement, for what purpose these statements are used, that purpose is also mentioned in this section. Now, next section is 163, no inducement to be offered. While recording the statement, under section 161 of the code, the police officer who is conducting investigation cannot induce to the witness for making any statement. Today, we have discussed some powers of the investigating officer. In next time, inshallah, section 164, which is a very important section, and according to which the magistrate is empowered to record the statements of the witnesses and also to record the confessions of the accused during the investigation case. It will be, this section 164 will be discussed in detail. Thank you very much.